All right, I think we're ready to proceed on our second hearing today. The case is from Sedgwick County. It's number 120-134, entitled The State of Kansas versus Christopher M. Bliss. I see that we have Mr. Maloney and Mr. Mahari with us today for argument. You are both frequent flyers with this court, so I'll dispense with any preliminary statements. And let's just jump right into this hearing. As I understand, there's an agreement. This case has an appeal and a cross appeal on both sentencing and conviction issues. We have an agreement between the parties that was initially suggested by the court that actually the defendant will argue first and be granted 15 minutes to argue all issues. That will be followed by the state for 15 minutes on all issues. Then we will give the defendant a 5-minute rebuttal. And then finally, since the state is the official appellant in this case, the state will also be granted 5 minutes of rebuttal. So you're actually being granted 20 minutes per side for argument. Counsel, I presume that's how we plan on proceeding?
Yes, Your Honor.
All right. So with that, Mr. Mahari, you will proceed first and go ahead and you can start off with up to 15 minutes to address all issues in both the appeal and cross appeal, bearing in mind that you'll get a rebuttal later.
Thank you, Your Honor. May it please the court, Peter Mahari for the appellee cross appellant, Christopher Bliss. And what I'd like to do with my initial time is start with the sentencing issue and then move on to issues 2 and 3 in the brief we filed as the cross appellant. And in this case, my client was charged with several charges out of a domestic incident. Eventually, he was convicted of a couple counts of aggravated kidnapping, a battery, and then was sentenced to a downward durational departure of 84 months or 7 years in prison. The district court in this case granted that departure based upon 2 factors that it cited, and that was leniency request by Mr. Bliss's wife, the state's victim in this case. Secondly, district court departed because it found that he had no violent criminal history, nothing on par with the charges that he faced in this case. And as this court looks at downward departures, there's several questions this court has to ask. One is whether or not the departure factor cited can legally be a departure factor. It has to ask itself whether or not there was substantial competent evidence to support those departure factors. And if both those questions are affirmative, this court uses a standard of review of abuse of discretion to determine whether or not the departure was proper, i.e., whether or not there was no reasonable person who would agree with what the district court did in this case. And it's our contention that there is both 2 legally sufficient departure factors, sufficient evidence to support them, and that this court can't say that no reasonable person would ever agree with what the district court did in this case. With regard to the factor as far as my client having no violent criminal history, it's true that you just can't look at criminal history and say that's a departure factor. But this court has said in the past that you can look at factors regarding a person's criminal history that are not taken into account in the guidelines. And the guidelines just take into account person, non-person, misdemeanor, and felony. And as we pointed out in our brief, person felonies are not necessarily violent. Cora is a person felony. And some non-person felonies are not necessarily violent, are violent, even though they are not person felonies, such as loading a spring gun, which my colleague found and put in his brief. So when the district court said there is no violent criminal history, it is not just looking at the criminal history, it is looking at and comparing what my client's prior crimes were to what he was looking at in this case. And this case certainly is out of character. He had a possession of meth, a couple driving offenses, and that's it. So when you look at the charges in this case and what his prior criminal history showed, this is the aberration. There's nothing violent in my client's past. And that difference can be looked at because it's not taken into account just by the criminal history of the guidelines. And that difference can be a departure factor. And certainly there was substantial competent evidence. Just a quick look at the PSI shows, again, that he had no violent criminal history. Just a handful of very minor offenses.
Mr. Meharry, is it your position that that departure factor itself is sufficient to warrant the court's action here?
Yes. When you look at downward departures, if the district court cites more than one, even if it cites 5 or 6 and 5 of them are not good, if there is one that is sufficient, then that is sufficient to support the departure. And this court can look at just the factor that my client had no violent criminal history and see that it is a legal departure factor. It is supported by substantial competent evidence. And again, going back to the standard view of abuse of discretion, I don't think this court can say no reasonable person would agree with that. So that is a valid departure factor, and that alone can support the departure in this case. We believe both are sufficient departures and adequately supported by the evidence. In this case,
Can you talk me through the district court's other departure analysis? That's the one I'm having some real difficulty with in light of the Hines decision.
certainly in this case, MB asked for probation. She asked that multiple times at sentencing. Sentencing occurred over 3 hearings. And she was clear that she wanted leniency. And this was part and parcel with her recantation of what she originally told the police. She told the police later in her recantation, I should say she told the public defender's office, this was blown out of proportion. There was a fight, she admitted that, but it was a fight about finances, but it wasn't on the scale that the state made it out to be. And she wanted leniency. She told the court that my client was the breadwinner, that she needed him as a husband and as a father. They have children together. Additionally, she pointed out to the court, despite what the state is saying and despite the insinuations the state wanted to make about my client being a domestic abuser, a serial abuser, she had been with him for 15, 16 years. And not as, again, as we look at the PSI, there is nothing in his record that would show any violence in the past. So I think 2 things. Number one, the court certainly had concerns and it noted that. But, and this goes, I think the state really wants this court to weigh her credibility. And the district court made that determination because he saw and heard her. And while he may not have taken everything she said as the truth, he did take into account that she wanted leniency and felt that that was a sincere position, and he gave it weight. So I think her position
But didn't the court actually weigh the credibility and find that she was not credible in her request for leniency, but nevertheless she asked for leniency, and so I'm going to give it to her? I mean, isn't that kind of the nature of the analysis that the court engaged in?
I don't think he necessarily found her not credible. I think the court found that she was probably conflicted. She had competing interests, I think is probably how the court looked at it. And I think even if, like I said, even if the court didn't believe everything she said was the truth, it still can give and did give weight to her request for leniency. The district court could look at this and say, look, I think it's more severe. This incident between you and your husband was more severe than either my client would admit or she would admit. But it's not to the level of the state, what the state is arguing. And given her needs, as far as having him home to help be a father, be a husband, that carries weight. And that is a factor that the district court took into consideration and felt warranted something less as far as a departure goes. The district court didn't go all the way where defense counsel wanted, where MB wanted him to go. That was to probation, but he did depart durationally. And I think the district court could kind of look at what she was asking and kind of parse it out and say, I have some questions about whether or not you really recognize what's the issue here, but I can also recognize that this isn't as bad as the state says. And there are other factors that warrant a downward departure so that I can, lessen the sentence so that she is not on her own for as long as the state wanted, so that they can have more of a family. So I think the court was kind of parsing it out and found that her request for leniency was sincere and was a departure factor. I think that is different than Hines. Hines, the facts were the husband slashed the wife's throat in front of the kids, in front of a neighbor multiple times, and then stabbed her down the chest and eventually pled to attempted second-degree murder. In that case, the wife asked for leniency and told the court that she didn't believe that the defendant ever really had any intent to kill her. And that was just contrary to the facts as pled to by the defendant in that case. So I think the gravity of the injuries in that case and the contradiction from what she was saying to what was pled to make Hines a different cat than what we see here. Certainly all along, the defense in this case was that this was, while they may have had a dispute, it was blown far out of proportion by the state. And that is certainly something I think the district court could look at and see. And the injury in this case was a cut to the finger. That was it. So given those facts, it's certainly, I think, well within the district court's discretion to give weight to her request for leniency to support a downward departure.
Counsel, I'm sorry, Judge Malone, did you?
No, I was, go ahead.
Can you tell me the timeline between her initial statements and her recantation? Like, what was that time frame?
The incident happened in March, I believe, of 2018, I think early March. And then she gave her recantation in August. I think so that's about 4 months later, 4 or 5 months later. And she stuck with her recantation throughout. Once she made her recantation, she stayed with that. And certainly, as this court knows, reading the briefs, she was found unavailable for trial at the state's request. And then the district court excluded her recantation from trial. So it never came into trial. But then when it got to sentencing, she stated multiple times, as I said before, the sentencing took place over 3 hearings. She stated multiple times that this wasn't what I originally told the police. It was far less severe. And in the process, she was asking for leniency. So when you look at, and if there are no other questions, we'll move into issue 2. When you look at the overall picture of this case, what we have is a witness who said one thing initially, and then came back and said something different. Yet the jury only heard one of those statements. And it's our contention that it was improper for the district court to exclude from the jury trial her statement recanting what she had originally said to the district court. This was a little bit of an odd case in that who the state was saying was the victim, was found to be unavailable at the state's request. The state was having problems finding her, and then eventually moved for her to be found unavailable, which the district court granted, and then they used her preliminary hearing. But as I said, the district court did not allow the recantation, and we believe it certainly fit within the exception to the hearsay rule as far as a statement against interest. And I understand.
Counsel, can we reach that issue? And that was never raised, right?
We believe you can. And we recognize that at trial, they argued that it fell under necessity or present sense impression exceptions. But we believe you can for a couple reasons. Number one, we believe this is a fundamental right and it needs to be addressed to protect my client's fundamental right to present a defense and essentially protect my client's right to a fair trial. In the interest of fairness and justice, we think that this needs to be addressed. And that is one of the exceptions to issues not raised below.
But do we apply those preservation exceptions to what is an evidentiary issue here?
We believe you can. We don't think that the preservation exceptions have an exception for evidentiary rulings.
It certainly does on the improper admission of evidence. Under 60-405, the Supreme Court is very strict. If it's not preserved, you can't raise the issue on appeal. The question here is whether or not that same strict rule applies to an erroneous exclusion of evidence under 60-405, which I think is a very unique issue in this case.
And we don't think it does. The statute, as you pointed out, talks about erroneous admission. So this is a different circumstance. But we also think that, when you talk about the exceptions for issues first raised on appeal, they don't talk about, excluding evidentiary issues like the one we have here. They just talk about, okay, you didn't raise this issue below. Well, the exceptions are, is it a question of law that's determinative of the case? We believe that this is. Or is it necessary to serve, fundamental rights and interests of justice? We believe it is. So I don't think the exceptions exclude this court from addressing the issue because it's an evidentiary issue.
Counsel, do you know whether there has been any consultation with the defense trial counsel to ask why 6460J wasn't raised below?
I do not, Your Honor. I'm not on the brief. I don't know if my colleague did talk with counsel below as to, I guess, what the thinking was and why they went that route. From our vantage point, we think the clear exception here is a statement against interest. When you read the recantation, she talks about lying in a letter to a judge. She talks about how what she told the police wasn't true. This is all statements that go contrary to what she testified to at the preliminary hearing, sworn testimony. So we believe it clearly is a statement against interest. And I don't know necessarily that the state is really arguing otherwise. I'm sure Matt will correct me if I'm wrong, but they seem to be more focused on the preservation issue. So we believe it clearly does fall within that exception and should have been admitted at trial. And given the statements, we just don't believe that this court could find that that was harmless. Certainly, as I said before, kind of looking at this globally, the victim, the state's victim, said two different things. The jury only heard one. We don't think that's either fair or indicative of what a jury would do if they had heard both statements. We think a different result would have resulted if the jury would have been given both statements and given those statements to weigh the credibility and determine what actually happened at this time. So given the importance of it.
Counsel, I shouldn't know this, but is the proffered or is the recantation proffered in the record? Is it located somewhere in the record?
It is. I'd have to look at the table of contents to find where it was, but I can do that quickly. It is been made part of the record. It's I have it in front of me. It's about a 3-page document. Her original statement was in Spanish, and then it was translated by one of the translators for the district court. So it is in the record, and I'll see if I can't find that site. Not sure where I'm at time.
Well, I'm giving you a few more minutes, so why don't you briefly address, you said there was one other conviction issue.
The other one I was going to address was the third issue, which deals with AB's statement. Again, these were statements that were brought in through hearsay under the exception, or because AB was found unavailable. Again, a little bit of a different case in that two of the main state's witnesses were unavailable at the state's request, but they involve statements AB, my client's daughter, made to a police officer and then a 911 call. We believe that they clearly should have been admitted as they are testimonial statements and violate my client's right of confrontation. He never had an opportunity to cross-examine her before trial, and when she was found unavailable, he never had an opportunity at trial. The state, again.
Counsel, what does the district court need to do? In looking at the record, it looks like the statement was just basically, just for the record, I want to record my objection with regard to an unavailability finding because we won't be able to cross-examine her. But there wasn't any argument that these were testimonial statements or even a mention of the confrontation clause beyond we can't cross-examine her. Was that enough to trigger the district court to make it sua sponte a determination as to confrontation?
We think it was. The only reason to say I'm going to object because I haven't been able to cross-examine this witness is to raise a confrontation claim. And that's where it comes into play. So we think that by stating that to the district court, it was properly preserved and the district court should have looked at it through that lens. It did not. And that was the problem, because if it had, it would have ruled that these were testimonial statements and should have been excluded. So we believe that the objection was sufficient. Whether or not it was the perfect objection, whether or not, the trial attorney gave a 2-minute treatise on confrontation, no. But we think that the way the defense counsel objected at trial was sufficient to raise the issue and put the district court on notice that the issue was he never had an opportunity to cross-examine this witness, and that's a confrontation problem. Everybody knows it's a confrontation problem, so we think the district court was or should have been on notice that, okay, I need to look at this in that regard. So we believe it was properly preserved. And in this case, the state, their argument against this issue is that it wasn't properly preserved. They haven't argued the merits of the issue, so that, when you look at these, we think it clearly is testimonial statements and should have been excluded. And again, much like the statements or the recantation with MB, we don't believe that this error can be viewed as harmless either. It is one that definitely had an impact on the trial and helped the state. And we don't believe that you can say beyond reasonable doubt, had the district court correctly ruled, it would not have had an impact on the jury.
I've given you 20 minutes, so at this point, we probably should hear from Mr. Maloney. And the state, of course, will be granted a 20-minute argument on whatever issues you want to address. And again, you will both have your rebuttal time.
Thank you.
Thank you, Your Honor. May it please the court, Assistant District Attorney Matt Maloney for the state. I will start with the departure issue, and it is the state's position that both of the factors relied on by the court, that neither of them support a departure in this case. Starting with the first factor that the court looked at, which was the defendant's criminal history. The defendant's argument is essentially that the state is improperly treating violent offenses synonymously with person offenses. And counsel properly notes that Mr. Dunn in the brief did point to a couple examples of violent offenses that are not person offenses, and some person offenses that don't have any violent tendencies. And he argues that the court was essentially saying, hey, this wasn't simply a consideration of whether there were person offenses. This was a different issue. Well, when you look at what the court actually said in this case, it's clear that the court really did just simply look at the criminal history itself, because the court specifically said that it was the lack of these types of offenses, the violent offenses, that are the reason that this defendant fell in category F. So clearly, whether the court was using the word violent offenses or person offenses, he clearly was aware that what he was conveying is that the defendant didn't have any offenses that would have taken him or put him in a grid box beyond the F category. So I think the court, while the defense is correct that there might be a theoretical case in which the difference between person felonies and violent offenses might have some relevance, this simply isn't that case. Here, the court very clearly specified that it was precisely because he didn't have these types of offenses, any prior violent offenses, that he was not anything more than an F. So I think in this case, truly the court was referring to the fact that he didn't have any person felonies, even if the court didn't use that precise language. And therefore, it is our contention that it was not, as a matter of law, proper for the court to look at this as a factor, because that is something that is already baked into the criminal history and sentencing guidelines. If the defendant had, in fact, had prior person felonies on his record, he would have had a criminal history greater than an F. So really what the court did here is consider a factor that is already included in the sentencing guidelines calculation, and it's our position that that was erroneous for the court to do, and as a matter of law, that factor cannot be used to support a departure. So that leaves us with the second factor, which was the victim's desires. And I would acknowledge, having been the appellate attorney on Hines, that the Supreme Court in Hines did say and reiterate that the victim's desires can, as a matter of law, in certain cases, be a departure factor. And we don't dispute that. What I would urge this court to do is, I know my colleague in the brief cited a Florida appellate case in which the Florida appellate court essentially said that in domestic violence cases, courts should be extremely reluctant, if not unwilling, to ever rely on that particular factor in this particular context. And I argue that that is very good, well-reasoned logic by the Florida appellate court. All of us have enough experience working on domestic violence cases to understand that what happened in this case is far from uncommon. This was a situation where from the moment this defendant was arrested, despite the fact that the protective order was in place, he persistently attempted, in some cases successfully, to contact the victim either directly or through his family members. He texted, he emailed, he called. I think he did make, at least on one occasion, he did manage to have face-to-face contact. And he consistently tried to get her to not cooperate with the investigation and clearly wanted her to do her part to try and make this case go away. That's exactly what is so common in these domestic violence situations. And the victim in this case, for the first few months, was able to resist those overtures from the defendant. But ultimately, after having testified at the preliminary hearing, several months after having testified at the prelim, she eventually did stop cooperating with the investigation, and then came to sentencing and argued that she wanted the defendant home so that the family could be reunited.
Would you address Mr. Meharry's argument with regard to the court's kind of compromise ruling, right? That this is we're going to deny the dispositional departure, but we'll do a durational departure in light of some of these questions we have with regard to the victim's motivations.
Right, and I did appreciate your question to opposing counsel. As far as what exactly did the court find as far as credibility goes here. As I read the court's ruling, it seems fairly clear to me that the court did find that the statements that the victim had been giving in the early months of the case, both in the immediate aftermath of the crime and as she worked with the police liaison, the victim's advocate, the court clearly found that those were more credible statements than anything that the victim said at sentencing. I think the court's language was that he found those earlier statements to be more truthful credible, and that he viewed the statements at sentencing with a good amount of suspicion. Ultimately, what the court then said was, while I find those earlier statements to be the credible ones, I can't just ignore what she said here at sentencing. And that seemed to be the reason that the court departed, in addition to the criminal history issue. I would submit that the court was wrong in thinking that it could not simply ignore what she said at sentencing. And by ignore, I don't mean that it should not pay attention to it, but I don't think that the court was under any obligation to find any of those statements credible. The court certainly was within its power to use common sense and realize that this was no different than many domestic violence cases, where at some point in the process, whether it's days after the crime or months after the crime, the victim recants or simply refuses to cooperate, whether it's because of financial pressure, whether she's afraid of further violence, whether she doesn't have any idea how she'll be able to go on with her life without.
Sorry, counsel. So is it your contention then that she didn't really want the departure?
I think that I guess there are two ways to look at that. I think that perhaps at the time of sentencing, she did not, maybe she truly believed at that moment in time that she wanted the departure, because she didn't see any alternatives, and she thought that it was better than having the defendant go to prison for many, many years. But I also do think there's a real possibility that maybe she didn't want the departure and was simply arguing for it because she was afraid of the defendant, because she feared further violence, or she feared the economic ramifications that would come to her and her children if the defendant was incarcerated for 2 decades and she didn't have any income there. I don't think it's possible to know. I certainly wouldn't claim to know for certain what her true motivation was, but I think that either one of those motivations is something that is very common in a domestic violence situation, and that's why
I agree that is troubling. But from the standpoint of an appellate court, where we have a district court who has observed her demeanor at that time and has rendered a ruling, are we in a position to upend that determination?
Well, I think even if this court were to determine that part of the court's ruling was based on a credibility assessment, that the victim did in fact want a departure, you wouldn't necessarily have to disturb that credibility determination in order to reverse the court's ultimate decision to depart, because that gets to the third part of the departure test, which is whether, even if a substantial reason, even if a reason is supported by substantial competent evidence, you still have to assess whether that reason then is substantial and compelling and justifies, or in fact necessitates, a deviation from the status quo. And that's where I think it is especially relevant that this is such a common scenario, unfortunately, for survivors of domestic violence to, for whatever reason, want the abuser back in their life, and to not want them to go to prison at all, or certainly not to go to prison for as long as the guidelines would call for. And so, given how common this type of scenario is, I struggle to understand how it could, in this particular context of a domestic situation, how it could rise to the level of a substantial and compelling factor, even if you find that the defendant did in fact, or that the victim did in fact want the defendant to be granted probation. And that's why I think that Florida case law is what I would urge this court to adopt. I know you're duty bound by our Supreme Court's general case law that, yes, a victim's desires can be a departure factor, but I would urge this court to follow this Florida court as far as saying in a domestic violence situation, it should be very much the exception to the rule. And I don't think that there's anything about this case that makes it that. I think this is very much the rule rather than the exception, where you have a survivor of domestic violence.
I understand, counsel, but it seems like what you're saying is that victims of domestic violence should be ignored at the front and at the back.
I wouldn't say ignored. I think that the court should simply look at it through the lens of common knowledge and experience. And again, I guess even within the domestic violence context, I'm not arguing flatly that there could never be a situation where a victim's desires could rise to the level of a substantial and compelling factor. I think especially if they were in conjunction with other legitimate factors. But this case was a situation where the violence spanned many hours. It started one night. It only ended that night, I think, because the victim's child, the couple's child, was in the room. Then it continued the following morning. So this isn't even a situation where one could look at it and say that after some time to cool off, the defendant was able to do that, to calm down. Instead, he started right in the following morning, essentially doing the same thing, trying to force himself on the victim. And that was the encounter that ultimately led to the violence that resulted in an injury to the victim. So I certainly don't think victims should be ignored, but I do think that if there ever were to be a situation where a victim's wishes rise to the level of substantial and compelling, it would have to be a case with facts far different from what we're looking at here. And this resulted in the defendant essentially having 11 to 12 years taken off of his sentence. And I know that one of the arguments that the defense has made, both in the brief and at argument today, is to say that this case isn't nearly as serious as Hines. And I would point out that first, I think it's always a little bit dangerous to determine which domestic violence situation is more or less dangerous. There are all sorts of things that can lead to different outcomes in those types of settings. But I would point out that if you look at Hines, I believe that the defendant in Hines, his presumptive sentencing range was actually significantly less than the presumptive sentence that the defendant faced in this case. Now, granted, part of that is based on a difference in criminal history score. I think Hines was an H as opposed to an F. But nevertheless, I think any argument that a case that involved aggravated kidnapping and aggravated sexual battery, and even though the jury found him not guilty of the attempted rape, these were clearly very serious crimes. And I think I would certainly say that we're just fortunate that the victim didn't end up with more severe injuries than she ultimately did.
Counsel, I do want to have some time to move on to those conviction issues. Because I have some questions with regard to the state's briefing on those issues. Can we start with the confrontation issue with regard to AB? My question is this: it looks like the state's position is that that was not preserved, and that's the reason we shouldn't reach it. If we do reach it, if we disagree with the state on that point, is the state conceding that this was a confrontation error?
Your Honor, I wouldn't go that far. Obviously, I didn't write the brief, and I don't want to speak for my colleague or my then colleague who did on that. I think it's just more of a reflection of the fact that the state's position is, at the time of briefing, the state was confident that the case law does support our position that this was in fact not preserved, and therefore it not being preserved, the state chose not to address the merits. And I will certainly address the second part of that question as I proceed here. I do want to start, with the court's permission, by just reiterating or explaining why our position is that it was not preserved. And I think your question to opposing counsel touched on this. This was a situation where at the pretrial hearing, I believe there were 25 or 30 pages worth of transcript where this issue was addressed. And it was addressed and analyzed under a statutory hearsay framework. The court ruled on it under that framework. Then the parties and the court moved on to an entirely separate issue, which I think had to do with the state preparing to file another amended complaint. And after several pages of discussing that, as Your Honor pointed out, it was just kind of as an aside or a quick throwaway that defense counsel made the statement about wanting to preserve an argument with respect to AB's availability and whether she had been subject to cross-examination. I certainly don't think that that meets the requirement for a timely and specific objection. It wasn't. The issue had already been ruled on by the court at that point, and there had been much discussion about it. And at no point during that discussion did counsel make a confrontation clause argument. And even when counsel made the 1 or 2 sentence statement about wanting to preserve an argument with respect to the availability or testimonial nature, still there was never a mention of the confrontation clause directly. And our position is that it's not the district court's job, and in fact, it wouldn't be appropriate for a district judge to essentially read between the lines and guess as to what argument the defense attorney is making. That's counsel's job. The district court's job is to rule on issues that are presented to it by the parties. And I think it would have been overstepping for the district judge in that situation, after having just litigated an issue under statutory hearsay analysis, to then jump in and say, well, I don't think you really raised this. I've never heard you even use the phrase confrontation clause, but I'm going to go ahead and sua sponte address this. I think it's incumbent, and I think that not only statute, but the Supreme Court's case law on the need for a timely and specific objection is very clear, and has been even more clear in the years since King, that there's a reason that rule is in place. It's so that the issue can be properly analyzed under the necessary framework below. And I think that could be one of the reasons also why my colleague didn't really brief the merits, is because when you've not had that necessary analysis at the district court level, it's difficult to brief the issue. You're simply missing so much of the analysis. And I know one of the exceptions that the defense is trying to rely on is the argument that it's purely a question of law. And I would certainly disagree with that. I think that it's inherently factual when you're talking about something along the lines of whether something was testimonial, whether the victim is, or the witness is, unavailable. And if so, was that witness subject to cross-examination at an earlier phase? These are all inherently factual questions. And I struggle to understand how an appellate court or an appellate attorney could really engage in meaningful analysis of that, given the state of the record that we have.
Do you think, counsel, that our analysis of that point, which I read as falling under 6404, is different from our analysis of the recantation, which is under 6405?
I think that both issues are similar as far as the failure of the defense to raise a specific argument before the district court. I think that there are two different issues at play. One is the need for a specific objection, and the other is the concept that you cannot raise one ground before the trial court and then argue a different ground on appeal. So there are a couple of different statutory or case law rules that are in play here, but I think they're both similar in that they lead to the same outcome, which is that the defendant is trying to argue something different on appeal than he did before the district court. And again, our position is that the case law from our Supreme Court on this has been as clear as can be. And in the confrontation context, our Supreme Court has said many times that confrontation and hearsay are not one and the same, and therefore a hearsay objection is not going to suffice to preserve a confrontation argument. So I think there are a couple different statutes and a couple different rules in play here, but they ultimately both lead to the same place, which is a conclusion that neither one of these issues was properly preserved and therefore should not be addressed by this court.
Counsel, you're moving into your rebuttal time.
That's fine, Your Honor. I think I'd finished all the remarks I had planned at this point, so I will yield the rest of my time for rebuttal.
Mr. Meharry, we're back to you with your 5-minute rebuttal.
Thank you, Your Honor. A couple just kind of quick points. First, as far as the recantation, it is part of the record. It's volume 24. And like I said, it's about a three-page document where translated from Spanish to English, but that's volume 24. As far as the departure goes, I guess it's concerning to me. It seems to me the state really doesn't want the victim to have any say in this case when it goes against what the state wants. The state seems to want to say that she's not credible and that she shouldn't be believed. That is a question for the district court who sat in the courtroom, saw and heard her talk. And the district court did give more credit to her initial statements. And if you look at volume 17, page 57, it says, I've given the earlier statements more credit, frankly, than the statements she's made later. At the same time, I cannot discount what she said, and she seems to be very strident in her beliefs at this point. That's a credibility determination. The district court found that she truly wanted leniency and felt that that warranted a departure. And it's our view that if you have valid legal reason for departure, which a request from leniency from the victim can be, and you have substantial competent evidence to support it, it's then an abuse of discretion standard this court holds. And this court has to look and determine whether it can say no reasonable person would take the view and take the position the district court did. And I don't think you can say that no reasonable person would take all of the facts in this case, all of the statements, and conclude that a departure was warranted. That, I think, is a reasonable position to take. And further, there was a question of how severe this was. The state wants to, because the state can frankly charge aggravated kidnapping in a lot of cases that most people wouldn't think are kidnapping cases. So they charge severe charges, true. But there was a huge question as to how severe this was. And from one statement to the other, it's night and day, admittedly. But at trial, the jury, as we've argued in our brief, never heard one of the statements. We believe that's fundamentally unfair. But the state's position is that this is worse or as bad as Hines is based upon its theory of the case. And there's evidence that it's not that bad. Not only from a recantation, but also from the fact the only injury she had was a cut to her finger. And she maintained, after she recanted, she maintained that position for the next couple years through sentencing. So we believe that the district court properly weighed all of those factors and came to a conclusion that a departure was warranted. One other point on that, the state—
You have 1 minute.
The state wants to infer as far as violent, significant criminal history with person felonies. And that's not what the district court said. The district court said it looked at the PSI and found no violent or significant criminal history. And that's different than just looking at the PSI and seeing where he falls. So we believe that's also a basis to support the departure. And for those reasons, we believe the departure was proper. But more importantly, we believe that a new trial is warranted in this case and would ask this court to reverse for a new trial.
Thank you, counsel. Mr. Maloney, you have your 5-minute rebuttal.
Thank you, Judge Malone. Just briefly on the departure issue, and I guess to respond to counsel's argument that the state doesn't want the victim to be heard. Again, I certainly don't want my comments to be interpreted in that way. We absolutely think that the judge should and must listen to the victim and should take her desires and her statements into consideration. But we also feel that, first of all, you also have to use common sense and common experience when doing so. But then perhaps even more importantly, even after you've considered her wishes, you then have to consider whether those wishes rise to the level of substantial and compelling factors that would require you to deviate from the status quo. And I think on that final point, that's where we feel that there's simply that no reasonable person would agree that in this particular case, that her request for leniency would rise to that level. It's such a common thing in domestic violence cases that it certainly does not demand a departure from the status quo. And so again, yes, by all means, the judge should and must listen to the victim, respect them, but also must filter that through common knowledge and experience, and then must determine whether that request by the victim requires a deviation from the standard sentence. And our position is that it did not. And then just briefly to touch on Peter's final comment with respect to the distinction between person and violent, I would again just urge the court to look specifically at what the district judge said after summarizing the criminal history. The judge specifically said, "That's why you're an F." In other words, that criminal history or lack of same is why you fell in the grid box that you fell in. And so that's why it's our position that the court truly was simply looking at the criminal history itself and then improperly used that as a basis to depart when it had already been factored into the presumptive sentence. It's our position that the district court did err in granting the departure, and we would request that that sentence be reversed and remanded. And as to with respect to the trial issues, we argue that many of those were not properly preserved and that they do not require any relief. I did just briefly, the first issue raised by the defendant in the brief, we acknowledge that the defendant cannot have two sentences for these two aggravated kidnapping convictions. I don't know whether it's truly a sufficiency issue as much as it is an instructional issue, but I think the practical effect would be the same, that we would acknowledge that it would not be correct for this defendant to have sentences on both of those counts. But again, our position would be that that wouldn't have any practical effect. And if the state's departure issue is upheld, the defendant would nevertheless need to be resentenced in the first place on the primary count. So there, without any other questions, we would respectfully ask that the sentence be reversed and that the convictions would be upheld.
Hearing no questions, counsel, thank you both very much for your briefs and your arguments. They were very good. And we will get a decision out to you just as soon as we can. And with that,